I think it's very clear from this judgment that banks are generally entitled to rely on due diligence, which has been done by third parties such as the fund manager. But the critical point here is that it has to have been done in accordance with professionally acknowledged standards. Now, saying that, if the bank has any questions or concerns with the information it's received from the fund manager, then it can't ignore it. It now, as is clear from the judgment, has a positive obligation to make further inquiries, to respond to those concerns and obtain satisfactory answers to any questions that the bank has. So I suppose the bottom line in all of this is that the bank cannot avoid its own obligations by relying on information from third parties. It has to carry out its own due diligence on a fund, and it has to do that with reasonable care and skill. Now, in the Standard Chartered case, the judge, Mr. Justice Chan, he reviewed made a very detailed analysis of the due diligence which had been carried out by the bank. And he concluded, after reviewing all of the evidence, that there was no evidence that the bank could have discovered the Ponzi scheme, even if it carried out a more comprehensive due diligence process. So I suppose, in other words, the judge found that there was no evidence to show that any potential failure in the bank's due diligence process actually caused any loss suffered by the investor. I think where a bank is relying on due diligence, which it receives from a fund manager, I think it's critical that the bank ensures that the fund is a reputable, professional organisation, and that that fund itself complies with professionally acknowledged standards. So the message from the judgment is that where the bank is conducting its own due diligence, it needs to be thorough and it needs to be proactive with its initial due diligence and ongoing due diligence. Situations change, facts change, so the bank has to be alert to that. It can't just, sit back once it's done due diligence at the outset and think that's the job done. It's an ongoing process, and the banks have to be aware of that and ensure that the appropriate systems are in place to make sure that situations are being monitored and any follow-up action is being taken by the banks. Now, in this case, it's very interesting because Mr. Justice Chan, he actually did a full analysis of the due diligence which had actually been conducted by Standard Chartered. Now, what is clear is that the bank had a very thorough and comprehensive due diligence process. For example, the bank had analysed the returns by comparing them against industry benchmarks. They'd reviewed the due diligence questionnaire prepared by the fund manager. That contained information about the fund manager, the history, the management structure, the strategy, the track record. They also studied 12 years of audited financial statements from PwC. The senior employees of the bank had actually attended meetings, held discussions with the investment manager. So I think overall, although in this case it is very unusual in the sense that the bank had actually conducted a very comprehensive due diligence process, the judge concluded, as I said before, that almost, even if the bank had done more, it would not have discovered the Madoff fraud. This, we should also bear in mind in this context that the banks already have separate due diligence obligations in relation to financial products as opposed to the fund promoting those products. Now, although they're very different, there's clearly going to be a degree of overlap between the two sets of obligations. For example, in relation to the obligations regarding financial products, the SFC has already stated that a bank should develop a thorough understanding of how the product works, including the nature of the underlying investments, the level of risks that they bear, the experience and reputation of the product issuer, which again is relevant to the obligations as far as the fund manager is concerned, and of course also the relative performance and the liquidity of the investment products. The SFC has also stated that the bank has to consider the market and industry risks and other factors which might affect the risk return and the growth potential of a particular product.